All right, hello and welcome to this evidence video capsule. Today I'm going to look at a very specific issue. I'm going to look at whether Section 5 Sub 2 of the Canada Evidence Act is still useful and whether or not witnesses should invoke this section when they are forced to give incriminating evidence in a judicial proceeding. I'm going to deal with that in detail and explain for those of you who don't know what this section actually does, but let me cut right to the chase. The answer is yes. I've investigated this quite closely for some research I'm doing, and I believe there is at least one situation, if not more, in which Section 5.2 of the Canada Evidence Act is more useful than Section 13 of the Charter, upon which most people rely. Your witness, if you are counsel for this witness, should always invoke Section 5.2 when they are giving evidence that has the potential to be incriminating, and in this blog, I'll explain why. So let me start with a very brief overview of how these two separate provisions, Section 13 and Section 5 Sub 2 of the Canada Evidence Act, actually work. And you have to understand the scenario we're dealing with here. This is Bob's trial. So Bob is on trial. Only Bob is in jeopardy in this particular case. Johnny is the witness. But he is the witness we are worried about. Because what's happening is he's a prosecution witness and he's being called to testify against Bob. And at common law, and something you've probably seen, in American television and the movies, Johnny would invoke his privilege against self-incrimination and refuse to testify. Or in the US, that would be called pleading the Fifth Amendment. I'm not going to give any evidence because it could be used against me. Canada doesn't allow that to happen. Johnny, as I will show you, has to testify. So Johnny gets up and testifies truthfully and makes what we know is called an admission of guilt. Okay, and that's essentially what it is. This is the type of statement that's normally admissible in a trial against Johnny, but as we'll see, Johnny is given protection in exchange for making this admission. And to make this as concrete as I can, if the prosecution gets up, now it's Johnny's trial, and tries to tender this particular admission, it simply wouldn't fly. Johnny's lawyer would immediately object, and I can tell you that he would win that objection. The judge would rule that regardless of what Johnny did, regardless of whether he objected, anything at all, Section 13 of the Charter prevents the admission of this evidence, and I'll show you exactly how that works. It's a basic precondition. So Section 13, and let me just suggest to you, I have a full video blog capsule on this, and if you're confused about Section 13, you can go take a look at it, but it's very simple. It essentially provides a compromise. The idea behind Section 13 is that instead of allowing witnesses to object to giving evidence that's incriminating, because that evidence could be used against them, we provide what I call back-end protection. We force the witness to give the statement, but then we make it clear that the prosecutor cannot do what the prosecutor tried to do against Johnny. Has the right not to have any incriminating evidence so given used to incriminate that witness unless it's a perjury count. So if the witness lied, that's something completely different. But aside from that, Section 13 is pretty absolute. Now, let me just say, Section 13 is a really confused area of the Charter. I'm doing some detailed research on this section, and I can tell you that where it's going right now is very complex, but I can also tell you that most of those complexities have nothing to do with the scenario I'm dealing with here, which are a straightforward incriminating admission like the one Johnny gave. So that's the only thing I'm concerned with here. Johnny was compelled to give that evidence. This is the situation in which Section 13 of the Charter is absolutely and clearly applicable. But as you know, the Charter was enacted in 1982, and before we had the Charter, witnesses in Canada were not allowed to plead the Fifth Amendment either. And the reason for that was because of Section 5 of the Canada Evidence Act, which I should tell you is still in force. That's the point of this entire video blog. My question is it worthwhile to use this section when you have a constitutional protection that is apparently, in some ways, as I'll show you, much broader? But let me just tell you how this works. Section 5 has two parts. The first part removes the privilege against incrimination. So essentially what this does is abolishes the common law rule that a witness could object against a question that would incriminate them. But it does so by once again providing protection, and this should look very similar to what we have in Section 13. The biggest difference is that the witness has to object. So you have to specifically lodge a Section 5 sub 2 objection on the ground that the answer may tend to incriminate you, and then it goes on to provide back-end protection. So the real question that I'm asking in this video blog is, well, why would a witness do this? This is an archaic, old protection, and Section 13 is a modern protection. Is there any reason to continue to object? Because you have to lodge an objection under Section 5.2. If you don't get the protection of this section. And let me just show you why. In a lot of circumstances, it is generally viewed that Section 13 provides analogous protection. So this is commentary from a very recent case in the Superior Court where a witness was objecting in response to each and every question. But it's interesting that all the lawyers in this case agreed that you don't even need it because the Charter provides blanket protection. Right? Why object under Section 5 sub 2 when the Charter provides blanket protection? And I can just tell you that I ran a little survey on Twitter before creating this video blog early in December, and most lawyers took that view as well. Many of them, thought it was prudent to object under Section 5.2, but it was generally assumed 85% of the survey respondents said, no, Section 13 is better than Section 5.2, and it covers the exact same field. And I should probably point out that by and large, Section 13 is better. There's no doubt because it applies whether or not it's invoked, so it's automatic. In fact, although I'm gonna suggest to you in just 2 minutes' time that Section 5.2 I think covers a very important situation that Section 13 doesn't, I don't think that should be the case. That's just the way the law has been interpreted. I believe that Section 13 is better and should be comprehensive because it doesn't have to be invoked. It's stronger, more useful, more appropriate protection, but it hasn't been interpreted that way. But we'll get to that in just a second. It applies to proceedings of any type. It's not about criminal or civil because the CEA is only applicable for federal proceedings and you have to use the corresponding provincial legislation. Let's just say there's some jurisdictional issues that arise when you're trying to use federal versus provincial legislation to invoke particular protections. It sort of depends on which jurisdiction you're in. More importantly, Section 5.2 cannot be revoked and nor can any of, in contrast to Section 5.2 or any of the provincial protections. So Section 13 is very important. I'm glad we have it. It's rockin'. But it's got one flaw, in my opinion, that needs to be addressed in the jurisprudence, but until it is, I believe everybody should always invoke Section 5 sub 2 when they're in a federal proceeding and the corresponding provincial protection when they're in a provincial proceeding. Here's why. So I think Section 13, in terms of the jurisprudence, has a major flaw, and here's where it is. If you remember, when the prosecution tries to admit this particular statement to convict Johnny, it cannot do so. Section 13 protects against that use. But what happens if Johnny is convicted, and they want to use the former statement that was given, compelled, at a prior trial, as an aggravating feature? So something along these lines. And don't worry about whether or not this actually shows this. I'm just doing this condensed to give you the idea. Let's assume that Johnny does make an admission that shows that he was acted in extreme malice and planned things. This is an aggravating fact on Johnny's sentence, because imagine if at Johnny's trial he doesn't testify. Now this statement is not used against him, but he's convicted on other evidence. And then the prosecutor wants to use this to show what Johnny was thinking. Now you have an aggravating factor because this statement shows Johnny's mental state, which he didn't get because he didn't testify at his own trial. Can the Crown do that under Section 13? I believe the answer is yes, and the reason is because of the wording of Section 13, which says the following: a witness who testifies has the right not to have any incriminating evidence used to incriminate that witness. What does that mean? Well, I hate to break it to you, at the sentence proceeding, the testimony is not being used to incriminate because Johnny is already guilty, and that's exactly what the courts across this country have found in a series of cases. The most significant of these is the Alberta Court of Appeals decision in Irving, where the court relied on another decision in Jones, which is not exactly analogous, but it's pretty close, where the Supreme Court concluded, I don't think that's what they concluded, but it's close enough, that they had no application at the sentencing phase because there's no incrimination. So without the possibility of incrimination, you can use statements of accused persons to aggravate their sentencing. And again, let me stress, I think this is a controversial position, and I think there's a good argument to make against it. But I can tell you that there's a series of decisions. The latest case in Nedelcu supports Ervin. I don't think it was on point. It wasn't actually deciding this. But by and large, they made it clear that Section 13 is designed to prove guilt. It's not about sentence or aggravation of sentence. It's about guilt. So therefore, there's good authority that's been cited by multiple courts to say, no, Section 13 does not protect against use at a sentence proceeding. And let me just say, I think that's terrible, and I'm going to be arguing against it in an article in future, because I think it's troublesome that you compel an accused person, you take away the privilege against self-incrimination, you compel them, you force them to testify, and then once they testify honestly, you then take whatever they say and use that against them as an aggravating feature on sentence. I think that's a problematic interpretation of Section 13, but it is the governing interpretation. So how do you protect against it? To me, the only way is by using Section 5, because Section 5 has different wording. So look at this. So the witness has to testify. That's subsection 1. And they have to object on the ground that their answer may incriminate him. Well, would Johnny qualify under this? Yes, he was objecting, he was giving incriminating evidence. But the key point here is that Section 5 protection is not restricted to evidence that is used to incriminate. Look at the wording. The answer so giving shall not be used or admissible in evidence against him in a criminal trial or other criminal proceedings like a sentence hearing. I don't think the language could be any more clear, and I think the Crown would have an incredibly hard time suggesting that evidence that was the subject of an objection under Section 5.2 could nonetheless be admitted as an aggravating feature on sentencing. For me, that is a very important factor for an accused to consider when they are compelled to give evidence in a separate proceeding. An objection under Section 5 sub 2 could be the only way of ensuring that this evidence is not used against you. As I see it, that's the state of affairs today. Under Section 13, this is permissible. Under Section 5 sub 2, it's not. And until the jurisprudence under Section 13 evolves, assuming it ever does, witnesses have to invoke Section 5.2 as a precautionary measure to ensure statements are not used to their adverse detriment on sentence. That's all I have to say on this particular subject. I hope it's of interest to you, and I'm happy to take any comments you might have. Have a great day. To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.